Hello, I'm Mark Miller, a partner in the law firm of ManfrediLevine. Today's topic is issues between neighbors. Living in a home can be extremely rewarding and lead to long-lasting friendships. Unfortunately, certain circumstances can arise that make that situation less than pleasant. These issues tend to break down into four distinct categories: nuisance and offensive activities, fences, walls, and trees. We will discuss today a situation where your neighbor is conducting activities on his property or is refusing to undertake necessary activities and maintenance in a way that is harmful or offensive to you. In this circumstance, you may have legal rights. After moving into a neighborhood, a person may discover that their neighbors are causing noise or odors, or may even be undertaking harmful or offensive and even illegal activities on their property in a manner that's extremely annoying to you. Generally, every person must refrain from conducting activities on their property that unreasonably interfere with the use and enjoyment by others of their own property. These activities are considered a nuisance and may give rise to legal relief. There are two different types of nuisances: a public nuisance and a private nuisance. If an activity affects you alone, it's considered to be a private nuisance. If an activity affects multiple properties, it may be deemed to be a public nuisance. Abatement through an injunction is only available to deal with a public nuisance. Therefore, if a private nuisance is affecting only you, your remedy would be to file a lawsuit seeking recovery for the interference with your use and enjoyment of your property and for any harm that may have been caused to your property. Certain factors must be considered in determining whether or not an activity actually constitutes a nuisance. The first factor would be whether the activity was being conducted before the complaining party moved into the neighborhood. In that circumstance, someone coming to the nuisance may not be able to recover. The second factor would be the degree to which the activity being complained of is compatible with the zoning and the use of the neighborhood in question. For example, certain odors may be associated with the maintenance of horses on a given property, but if the property is zoned for the boarding and care of horses, the person complaining would likely not be able to recover. Overall, neighbor situations can be extremely irritating and annoying because by definition you must deal with it each and every day. For that reason, we recommend that you attempt a friendly resolution before resorting to litigation in any situation involving a neighbor. A compromise solution is almost always preferable to a litigated outcome. Thank you for listening, and we'll see you next time.